10 o'clock on April 28th, Tuesday, April 28th. And I'd like to call the meeting to order and announce the time. It's 10 o'clock as of right now. If we get all the board members and those that are going to speak during the public comments to mute your phones or microphones and only turn them on whenever you're going to talk, just so it'll avoid any kind of feedback or technical issues. But always keep your cameras on if possible. Uh, and then also, one thing that's really important is to announce your name, which is really hard to remember to do that because it's not in our DNA. When you're speaking, because the names are going to be recorded and it's for the minutes. So with that, Carmen, I'd like to turn it over to you to do the roll call and certification of the quorum and introductions. I know we've got some new members, and we've got one member that's going to be joining us late, Andrea Fahrenhold. I think she's coming in at 11 or something like that. But Deborah and Stephen, it's the only ones that uh, I've worked with before on the board, but really want to welcome all the new members and really appreciate your interest and your willingness to take this on. We have had a national election, 2 legislative sessions, and 7 long years since we've met. So there's a lot to cover, and a lot going on in our industry. And we got a lot going on right now for our industry. We're all really busy. So we're going to try to make this a really productive time and good use of time. And but then get on with our business because we've all got to make a living. So, but we're going to give everybody the time that they want and all that they need. And if anybody has anything to say, just raise your hand and everybody's going to have a voice, including those public comments. So, um, Carmen, if you want to do the roll call and certification and on and on.
Yes, sir. Stephen Dunson,
Present here.
Deborah Balcom,
I'm present.
Andrea Fahrenhold, Artis Connor,
I'm here.
Chandler Crouch,
Present.
and presiding officer Steve Mills. We have a quorum, sir.
Okay, thank you, Carmen. So next, we'd like to call on Assistant General Counsel Mark Ladney for a presentation on our open government training. For
Did we
those that
want to
haven't
have
had it,
artists?
I'm sorry?
Sorry, did we want to have artists and do
Yeah,
the introduction?
artists, if you and Chandler would like to introduce yourselves and a little bit of background, we would really appreciate that. Artist, you
Go
want to
ahead, artist.
Okay, sure. My name's Artis Connor. I'm a 1998 graduate of the U.S. Military Academy. I served 9 years. Overall deployments in Bosnia, Kosovo, and Albania. Got out of the military right at the end of 2003, or I'm sorry, at the end of 2002, and have been in this business ever since. Started out at Harris County Appraisal District while I was in graduate school, moved to Pritchard and Abbott, and then an 8-year stint with Occidental Petroleum before I landed at BDO, Marvin Poor, and then now today at Betancourt Tax Advisors. So I actually specialize in industrial and personal property. So I think I'm a bit different than everybody else on the board. And it'll be, I guess, good to hear some differing perspectives.
My name is Chandler Crouch. I am a senior property tax consultant and real estate broker and husband since 2006. And I've got 3 kids at home and 1 on the way. And I got in real estate back in 2002. And then in about 2017 or so, I was looking for a way to kind of give back and just help people with needs in the community. And as a real estate broker, I served them the way that a lot of real estate brokers would, just providing general market information, that sort of thing. And then one thing led to another, started protesting for people. And it's just a passion to help people solve an important problem. And so now I protest for quite a few people just in Tarrant County. And it's led me to do different things, help with some legislative council stuff and let's see here, exposing some, just focusing at the local appraisal district here. So anyway, I'm excited to serve on this board and the new experiences, and I hope I'm able to contribute in some way.
Thank you, guys. I know you can. I know you will. And just appreciate your willingness and all the gifts that you guys can bring. Everybody has their own gifts and ads, but I just encourage you to don't be afraid to speak up. Everybody that I know, Stephen and Deborah and I, we've been on. It seems like we've been doing this since third grade, and it's a great business. It's truly. It's truly kind of a calling, I guess you could say. Um, and we certainly serve the public and the taxpayers, and we take that very seriously. Uh, and as you'll probably be able to see throughout this meeting, that we take it seriously. So with that, Mark, if you're ready, we'll call on Mark Gladney, who some of you know and have been introduced to. He's the Assistant General Counsel, and he's going to give us a presentation on open government training. And I can't tell you how important this is, that we don't violate that and having quorums when it's not legal and discussing things. We don't want to get ourselves in trouble. And so he's really going to give us information to keep us out of trouble. Mark, I'll give it to you.
Okay, thank you very much. Good morning, everyone, and welcome to the PTC Advisory Board meeting. Welcome to our new members, and also welcome to our veteran members. We'll say. Well, for the record, my name is Mark Gladney, and I will be presenting your open government training today. We do this with all of our boards, and I know that all of you either have or will have your training with the Attorney General's office. They have a couple of videos on the topics that we'll be talking about, and by law, if you haven't taken them, then certainly the new members, if you haven't taken them, you have 90 days to do so. So I would urge you to do so. But TDLR is committed to giving you a bit of a refresher, in part to show you how important it is that our boards do adhere to the law, the rules, and the procedure for the work that they do. So, having said that, we're going to get right to it. I'm going to try to share screen. Sometimes I'm a little technologically challenged, but this seemed to work a little while ago. So tell me when you all see the screen.
Got it.
Okay, great. Okay, we're going to get started. These are the three pieces of legislation that we're going to be talking about today: the Open Meetings Act, the Administrative Procedures Act, and the Public Information Act. Okay, starting with the Open Meetings Act. The purpose of the Open Meetings Act is basically to put some sunshine on the activities of governmental bodies. Simply to let the general public know the who, what, where, and why decisions are made by an advisory board on issues under its jurisdiction. One of the ways we do that is by making sure the public knows the when and the what we are discussing. And we do that with an agenda which has been posted before the 7 days before this meeting. Okay, so the provisions of the act are mandatory, and they are liberally construed in favor of open government or sunshine, as I just said. Now, when does the Open Meetings Act apply? Well, first thing we have to have is we have to have a quorum of members, like we do today. There's 7 members of this board. We need to have a minimum of 4. If we have a meeting with less than a quorum, and that happens from time to time, not as much now that we're doing these meetings remotely, but if we happen to have a situation where we have a meeting with less than a quorum, we can still conduct a meeting, but we just can't take any the board can't take any official action. Okay, and some other key elements of the Open Meetings Act is deliberation. The act applies when we have deliberation or discussion. Simple as that. The deliberation by this board is over issues within the board's jurisdiction. So, for example, you won't hear this board having discussions over the pros and cons of AC equipment or boiler systems because it's not within the jurisdiction of this body, and the Open Meetings Act isn't going to apply for discussions such as that. So we make sure that we stay on point. And the Open Meetings Act applies when we have a meeting, and a meeting occurs anytime that we have a quorum that engages in deliberation or discussion regarding public business or policy in which the board has jurisdiction. Notice is another important key element of the Open Meetings Act. All of our meetings will be noticed 7 days before a meeting. Board support will make sure a written agenda with the time and place of the meeting is posted with the Secretary of State and also on our website. The board may not engage in discussions about a subject that's not included in the agenda, and that's part of my job to make sure that if we have a discussion on an agenda item, and we stay within the confines of that agenda item, and we don't stray. You may occasionally hear me say, "Hey, we're kind of moving off of the topic," and that's just kind of a general reminder that we need to stay on topic so that we're not violating the Open Meetings Act. Now, another thing with regard to the Open Meetings Act, how does that apply if a quorum of you all happen to be at social functions, conventions, or workshops? And so you may find yourself in that kind of situation, and you're certainly free to attend those meetings and participate freely. But you just have to be careful not to have discussions of issues that are under the board's jurisdiction, and only have those discussions when we have a properly noticed meeting like we have today. Okay. So the key points to remember related to the Open Meetings Act is always be aware of any situation that you happen to find yourself in that's outside of a properly noticed meeting in which a quorum of you happen to be present or engaged in discussion. Next, don't engage in any substantive conversations regarding board business if there's a quorum involved and you're outside of a standard meeting. And then, of course, beware of the walking quorum. And you may ask yourself, what is a walking quorum? Well, a walking quorum occurs when fewer than a quorum of members engage in discussion about official business that should be before the board, and then communicate those discussions to other members. So an example of that would be 7-member advisory board like this one, and 3 members exchange phone calls and emails regarding an issue that's within the jurisdiction of the board. One of those 3 people decides and to forward that information to a 4th member. At that point, 4 of the 7 members are aware of those discussions that occurred outside of a regularly scheduled meeting. That's a walking quorum, and that violates the Open Meetings Act. So, again, the long and short of this is just make sure that if you're going to have discussions regarding issues that are within the jurisdiction of the board, have them at a properly noticed meeting, like right here. And it also has to you also have to have an agenda item that's been posted, and then you can talk about those issues that are related to that agenda item. So walking quorums can occur anywhere, conference calls, video conferences, just standard discussions. Emails is, can be a problem, but one of the biggest things is social media. So if you happen to have a social media account and, a number of the board members follow your account and you're making postings on that social media account talking about board business, you can basically have a walking quorum right there. Or just a quorum. So again, just be careful about when you're talking about board business, the circumstances, the atmosphere, and the locations in which you happen to be talking about board business. Best thing, talk about it here. Okay, so what's the best practices to avoid a walking quorum? The members should not engage in little small groups and discuss board business. I know it's tempting. I've been on boards and commissions myself, and occasionally you might get on a phone call and talk about some things, and invariably those things get passed along. So just be careful about that. Don't send emails or text messages to a quorum of members regarding official business. Even if you blind copy on it and you're sending them individually, don't do that. Don't create posts on social media about board business where it's possible that a quorum of members is going to see that. And don't ask a quorum of members, even on an individual basis, about issues that are within the board's jurisdiction. This is polling, and it's just kind of another way around the quorum requirement, but it does still violate the Open Meetings Act. So let's just avoid that as well. Again, this is an important deal. The board's limited to discussing the specific items on the agenda. If it's not on the agenda, we don't discuss it. It's tempting to sort of stray off the agenda and talk about some things that you may think are ancillarily related to the agenda item, but if we get around to doing that kind of stuff, I will gently nudge you to stay on topic. So very important to do that. We will have a public comment portion during this meeting, and I understand that we'll have 3 or 4 people that will be giving public comments to the board. The presiding officer can set reasonable limits on those public comments, and we usually set about 3 minutes. A member of the public or a member of the board may raise a subject that has not necessarily been included in the agenda. However, that's where the discussion stops. Any discussion of the subject has to be limited to a proposal to place a subject on an agenda for a future meeting. Okay, so to avoid violating the act, again, limited discussions to specific agenda items. Don't stray off of the agenda item. Don't respond to or discuss issues that are raised during public comment that aren't on the agenda. And we can always specifically identify items for future agendas, and we'll see about getting those things on either a future agenda, or it may be a topic that's better discussed in a work group. And work groups are very very helpful to getting a lot of things done, and I'll discuss that in a few minutes. Well, it wouldn't be a piece of legislation unless it had some penalties attached to it. So this one's no different. Open Meetings Act has civil remedies, and any interested person, including the media, can petition the courts to stop an action taken by the advisory board or any governmental body that's in violation of the Open Meetings Act. In that particular instance, the act states that any action taken in violation of the act is voidable. So you may have taken the act, but if somebody brings, or you might have taken the action, but if somebody brings an action in a court, that judge can declare it as a void action of the board. So be careful on that. Now, not only are there civil penalties associated with, there's criminal penalties associated with an Open Meetings Act violation. Members who knowingly participate in a walking quorum or knowingly participate in a meeting that's closed to the public are subject to criminal penalties, and those penalties can range from all the way up to $500 confinement in county jail for up to 6 months, or both. So it's just telling you the legislature takes it extremely seriously. a violation of the Open Meetings Act, and certainly so does TDLR. So that's why I'm talking to you right now and warning you that we need to stay on the straight and narrow on this. Do we see actions brought on the Open Meetings Act that often? Not necessarily. But I would say that in the last 10 years or so, we've seen a lot more action and litigation for those violations. So very, very important to be careful. Again, these are the best practices. I've already talked to you about these. So I'm not going to repeat myself. You'll also find them in your briefing materials. So I urge you to take a look at your briefing materials on these issues as well. If you have any further, curiousness or questions related to the Open Meetings Act, here are some resources. For those of you who have not taken the Attorney General training video, you click on that and it'll take you right to it. I believe the video lasts for about 40 minutes or so. And at the end, you'll get a little certificate that you can hang up in your office and, brag to your friends about it. And then here are some other sources of information that are very good if you have any further questions related to open meetings. And as always, if you all have any kind of questions whatsoever, you're free to call the General Counsel's office at the number shown, or contact board support, and they will route your inquiries to the appropriate division or person. So next, we're going to the Administrative Procedures Act. And the purpose of the Administrative Procedures Act is just basically to establish minimum standards of uniform practice and procedure for state agencies. And they also provide for public participation and transparency during the rulemaking process. So this is the act that we're going to be using a lot when and if we get around to doing rulemakings. What is a rule? A rule is just basically a statement of general applicability that interprets, implements, or prescribes law or policy, or describes a procedure or practice requirements of a state agency. So a rule basically, the easiest way to think about it is if the legislature passes a law that is a little bit confusing or ambiguous or needs a little bit of extra explanation, it's our job to create rules that help explain what the legislature is talking about in that particular law they pass. The rule excludes any statement, a statement regarding only the internal management or organization of a state agency. But a rule also includes a new rule, an amendment to an existing rule, or a repeal of an existing rule. Now, it's important for you to remember that a rule must have a basis in law. One cannot create a rule without a reasonable connection or nexus to an established law or statutory authorization to create the specific substance of a rule. So we can't make a rule that just is kind of hanging around out there. It has to be based upon a law that has been passed by the legislature and approved by the governor. Now, where do we get our ideas for rules for a program? Here are some of the places that we get our sources from. Obviously, bills. That's a big place where we get our ideas. They're not necessarily ideas. They're basically mandates from the legislature saying, this bill says X, then we must create rules that support what law X has said. Obviously, we get them from you. Advisory boards are some of our greatest sources of rules. Staff members for TDLR come up with ideas for rulemaking. Every 4 years, we have a mandatory rule review where we staff will go through all the rules associated with the chapter for a program and help make a determination with the advisory board and the commission as to whether or not the rule or the rule chapter is still necessary to administer your program. And then, of course, we'll get occasionally get a petition for rulemaking from somebody from the outside. As I said, advisory boards are a great source. And how do we get the inspiration from advisory boards? In meetings like this, but more often in work groups. Work groups are a prime example of rule inspiration. And we'll be talking later on in this meeting about work groups. But they are extremely important for us to get things done. Okay, petition for rulemaking. Any interested person can submit one to a state agency requesting the adoption of a rule. And, here are the examples of the who would an interested person be. Anywhere from a Texas resident to a business entity in Texas, or a governmental subdivision, or any public or private organization that's not a state agency but is in Texas. So here's our process for a rulemaking. Basically we start with on an idea. And I told you where the ideas for a rule come from. Once we get those ideas and we start drafting, we do internal review and analysis within TDLR. There is, after that, we finish the rule package. We send it to the governor's office for its review. And after we do that, we bring that draft rule package to the advisory board, and then we have a discussion about it with y'all, and make whatever changes that may be warranted, as long as we don't make any major substantive changes. And then once we get the approval from the advisory board to publish this rule, we send it over to the Secretary of State, and it gets published to the Texas Register. And then there's a 30-day public comment period during which members of the public can go thumbs up or thumbs down on the rule package. Some, all, or part of the rules, and they can even suggest changes to the rules. Then once that 30 days is up, then we review all the public comments. We categorize them, and then we bring them to the advisory board again. And then that's where we have a second discussion with y'all to talk about the public comments. And, there may be changes made as a result of those public comments. And then we will ask the advisory board for a recommendation for adoption that the commission adopt that rule package. So we'll ask you for that. After that, the proposed rules go to the commission for adoption. The commission will evaluate it. They'll evaluate the recommendation from the advisory board, and they'll adopt it, or they'll adopt it as it's been presented, or they'll adopt it with a couple changes. After they're adopted, a notice of adoption is filed with the Secretary of State and published in the Texas Register. And after that, there's an effective date for those rules. And after that effective date, those rules go start becoming the rules of the road for y'all. I talked about a 4-year review process. This is our process on that. Every program is on a 4-year schedule. We review whether or not the rules are still necessary to administer your program. And this is the flow chart that shows how we go about that. Okay. And last but not least, again, rulemaking resources for anyone who's curious. We have the Texas Attorney General's office produces a wonderful handbook if you want to know more about the APA. And then these are the statutory chapters that are associated with the APA. And again, if you have any questions related to the APA, you can always contact the General Counsel's office or board support, and they will refer your questions to the appropriate divisions. Last but not least is the Public Information Act. It's also known as the Open Records Act. And the Open Records Act is intended to allow public access to information about how government does its business. Again, this is dealing with sunshine or transparency in the the activities of governmental bodies so that the general public knows what it is we're actually doing. Public information includes any electronic communication on any device if it's in connection with official agency business. And the act is interpreted to grant requests for information. So that's part of the PIA. Now, whenever we get a request for public information, the request has to be submitted in writing. They could do that right on our website. The request is submitted to our records center. TDLR must respond to the request as soon as possible, but not later than 10 business days after the receiving the request. We can't ask someone why they want the records, but we can ask for clarifications. So anytime we get a records request, we respond as quickly as possible. Not everything is discoverable. And sometimes we will request an opinion from the AG's office to make sure that what we are disclosing, we can do so legally. So while there is this presumption toward disclosure, that does not mean everything is available, all information is available. The PIA has a large number of informational points that are protected, and there are significant consequences to anyone who would violate this law. TDLR has access to significant information about various numbers of confidential elements, and we do our best to protect it within the bounds of the law. Sometimes even advisory boards may request information that may not necessarily be disclosed under the PIA or even within program statutes. So if you want to know more about that, you can refer to the Government Code, Chapter 552, if you're interested in those exceptions. And as you can see on the slide, we do include some things that will be redacted from open records. Okay. If you all happen to receive a request for public information, or if you think you've received something that looks like a written request for public information, forward it to us as soon as possible, and we will address it within the confines of the Open Meetings Act. Okay. And again, here are the resources that you need related to the Public Information Act. The required video. There's a link right there for those of you that have not taken that video. You can click on that, and again, it's about the same amount of time as the open meetings video, about 40 minutes, and you'll get a certificate completion. And again, if you have any questions related to it, and you don't think about them, here and now, feel free to contact our office or contact board support. And that's basically all I have on the presentation. Thanks for your attention. And I'm going to stop sharing screen here if I can. Did that work?
It works. Thank you, Mark.
Okay. Thank you.
Well, I want to remind everyone, use that information. You're all smart people. You're adults and you're good business people. And just use your discernment. If you ever think something might be questionable, I'm sure Mark will just give him a call. He'll be glad to answer it for you if you think something's questionable. It did give me an epiphany during that discussion, and that's very strange at my age to have an epiphany of any kind, but it would be great to have that same kind of presentation on our own rules that we currently have, just as a reminder for people that are in our industry, straight from the book. What the penalties are, what the breaking of rules are, and it might be a good reminder for many people in our industry to see some of those and in writing and presented from TDLR. And then that might be a byproduct of our working group to make that as an agenda item. I don't know. It'll be dependent on the other members, what they think. But with that, thank you, Mark. We will next move to item D. And board members, if you have any comments regarding the minutes of our last meeting, September 19th, 2019, which seems ages ago. If there are none, I would ask for a motion and a second to approve the minutes as they were presented and as they were written. And if I can get a motion and a second on that. And Carmen, if you will do a roll call vote from that.
So
I'll make a
moved.
motion.
Yeah.
Oh, go
Nate,
ahead,
who
Deborah.
made the motion?
Deborah did.
Deborah? Okay. Second? Who's,
Second.
gotcha.
There we go.
Stephen Dunson?
Yes.
Deborah Balcom?
Yes.
Artis Connor?
Yes.
Chandler Crouch?
Abstain.
And presiding officer Steve Mills.
Yes.
Motion passes.
Okay, thank you, everyone. Now we'll move on to the public comment section, item E. And any person wishing to address the board must submit an email by following the public comments submission instructions found on the last page of this agenda or located on the TDLR website. Emails must be submitted to the board .comments@tdlrtexas.gov by 12 p.m. On Monday, April 27th, 2026. Public comments will only be accepted via email or video conference. We got 13 emails from the public, public commenters, and those have been forwarded to the board before this meeting. The comments will not be read during the meeting and cannot be discussed, but they will be a part of the board record and will be addressed by the board, in particular during our work groups. So everyone has a copy of those, and we will be addressing those during our work groups, which we'll discuss here in just a little bit. And then we also did receive, we actually received 4, but 3 are present, requests to speak during today's meeting. Each speaker will have 3 minutes to discuss and give their public comment. The board will not be allowed to ask questions or discuss anything said, but we appreciate those people that have taken the time to come forward and make public comments, and your voice will be heard. And I think the first one we have that is present is Mr. Glenn Goodrich. Thank you for being here. Appreciate it. And when you begin speaking, state your name and who you represent, and then you'll have 3 minutes to speak. And just understand that we can't ask you any questions or engage with discussion with you. It's just for your public comment. And
Okay.
Carmen will keep time, and you have 3 minutes.
Okay, thank you. Starting my clock. Thank you for the opportunity. My name is Glenn Goodrich. I'm a licensed property tax consultant based in Dallas. I am representing myself, I guess, in this matter, but I imagine I'm representing a few other people that are on this call as well. I wanted to discuss a growing trend in our industry, most acutely seen now through Hearst newspapers, specifically with my situation, it's the Dallas Morning News, but I understand it extends to Houston, San Antonio, Travis County as well. So the problem is that they have released a new service called Text Tax. It is a paid service where you pay $69 upfront, and the buyer receives it's a software, and so it's a software as a service. The buyer receives a equal and uniform, quote unquote, report, list of properties. It states an opinion of value, and it provides a script for the appraisal review board. And so my understanding of that is that is property tax consulting, and they are charging a fee for that. So it's unlicensed practice of property tax consulting. I did find a press release dated April 17th in 2026 where Hearst announced a statewide expansion of their text tax tool. It started last year in Houston, and they've expanded it statewide this year. And they explicitly said in that press release that it does not provide property tax consulting or representation. And that's likely because they know that they're not licensed to do that. The issue with that is that their interpretation of property tax consulting was wrong. It's very clear in the Occupations Code, Chapter 1152, a bunch of subsections, 6C.2, that property tax consulting services include consulting or advertising, or I'm sorry, not advertising, advising another person concerning an action the person may protest under subchapter C, chapter 41 of the tax code. And of course, tax code 41 discusses protesting of unequal appraisal. So selling a report to the public, advising them on an opinion of value and producing evidence for an equal and uniform report qualifies as that. Why this matters to me, I had a property tax service for a long time. I was a do-it-yourself as well. And I know that the relationship extends beyond just selling somebody a report. There's all kinds of follow-up questions you get. Hey, I got this offer from the appraisal district. Should I accept that offer? Blah, blah, blah. The list goes on for that. So there's customer service involved advising along with the protest as well. And I'm seeing more and more of these pop up beyond just the Dallas Morning News. There are services that you see all across Nextdoor and Facebook of people that have spun up their own services to do this themselves. So I think it's going to be a growing issue that we have to address now. And the Hearst newspapers is the biggest example that we can set for right now to do that. And I believe that was my time. So thank you.
Yes, sir.
Thank you, Mr. Goodrich. Great comments. Next, we have Mr. Louis Trujillo. Louis, thank you for being here. Thank you for providing your comments today. As we said, we can't really, respond or ask any questions, and you can't do the same. You can do the same, but please feel free. You have 3 minutes, and Carmen's tracking.
Awesome. Good morning, y'all. My name is Louis Trujillo. I'm a property tax consultant here in Dallas, Texas, representing myself. I have over 6 years of experience in the property tax field, serving first as a registered professional appraiser and currently as a property tax consultant. In recent years, there's been a noticeable increase in consumer confusion driven by certain firms improperly promising specific tax reduction outcomes, which is explicitly prohibited under Occupations Code Title VII, Chapter 1152, subsection 232. These practices not only violate statutory regulations, but also undermine the ethical standards of the profession. I respectfully request that TDLR more actively enforce the penalties associated with these violations to ensure accountability and protect consumers. As a property tax consultant in direct communication with both prospective and active clients, I regularly receive inquiries regarding outreach from other firms that promise specific outcomes. It is an ongoing challenge to address the confusion created by companies that have no basis to guarantee results without any knowledge of a property's individual characteristics. These firms frequently make assurances that they are not in a position to deliver, often appearing to rely on broad marketing claims rather than accurate or case-specific analysis. This approach contributes to widespread misunderstanding and raises serious ethical concerns within the industry. I encourage TDLR to increase oversight of marketing practices within the property tax consulting industry and to take prompt, consistent enforcement actions against firms found to be in violation of applicable statutes. Clear and decisive enforcement is necessary to protect consumers and preserve the integrity of our profession as a property tax consultant. And that's my comment.
Thank you, Louis. That was great comments, and thanks for your interest and taking the time to reach out to us today. We have another one. I think Nicholas Olenek is also. I'm sorry.
That's correct.
Yeah, is here to speak as well and provide his public comments. Mr. Olenek, you have the floor.
Thank you. Thank you, Advisory Committee and members of TDLR. My name is Nicholas Olenek. I'm a senior property tax consultant, 11804. I'm representing myself and my firm as well. I'm writing to discuss today the public comments for this Property Tax Advisory Council meeting. And just remember, this is the first since 2019. And I appreciate the opportunity to share concerns that are critical to the integrity of our industry. A primary issue that must be addressed is the lack of consistent enforcement by TDLR. While rules and standards governing property tax consultants exist, the absence of meaningful enforcement has significantly weakened their effectiveness. When violations go unaddressed, it creates an uneven playing field where compliant professionals are disadvantaged and non-compliant actors face little or no consequences. And to illustrate what I'm noticing in enforcement, and a real world example is in March of 2025, I filed a complaint. It's PTC 2025 0010182. 2025 0010182. That was over a year ago. There's been no action, no communication, nothing's happened with it. And we're an annual business in a way, given how reassessments are done in Texas. And it's alarming that something takes over 12 months to have any movement. To continue on, it appears also, just from open records I have done for PTC violations, that a relatively small number of companies account for a disproportionate share of complaints filed with TDLR. And if this is true, this further underscores the need for targeted and consistent enforcement. Without visible action, repeat behavior continues unchecked, which compounds the problem over time. The lack of enforcement is just not an internal issue, it's reshaping market expectations. Property owners are being presented with potentially aggressive tax savings estimates, and as a result, are now approaching other consultants expecting similar outcomes or choosing to work with those who suggest or perhaps imply a promise of the most significant tax savings reductions, regardless whether those projections are reasonable or compliant. This dynamic puts ethical and compliant firms in a really difficult position. We either maintain honest, supportable projections and analysis when we discuss cases with our clients, or we risk losing business or compete against presumably aggressive tax saving expectations that really don't align with the standards set forth for the PTC laws and guidelines. So over time, what this is going to do is erode trust in the industry.
Thank you, Nick. Time is up.
Thank you, Nick. And thank you all the speakers that came today. Great comments, great observations, and fact patterns. We appreciate that. Carmen, with that,
Excuse me, Mr. Mills. Did we have another public commenter, or is it just three?
It's
I
just three,
think
Mark.
just three today.
Just three? Oh, okay.
Well,
Because I was showing four, but okay.
Yeah.
All right.
Yeah. If it's okay, before we start, we're going to move item G ahead of F, which is the presentation of Enforcement Division processes of complaint cases. We're going to move that ahead of the staff reports. And also, I'd like to take a 5-minute break, restroom break, just to collect our thoughts, because I think the next half of this meeting is going to probably be kind of long. And if that's okay with everyone, does anybody have any qualms with taking a short break, 5-minute break? Hearing none.
What time would you like to resume?
It is 10:48 right now. Let's take 5 minutes. So 10:53.
10:53 return?
Yeah. Does that work? Thank you. get back on track. Thanks for indulging me, everyone.
I'm waiting on artist. Okay, here we go.
I'm here.
Got you. Stephen Dunson.
Muted. You're muted, Steve.
Thank you, Steve. Sorry, present. Sorry about that.
That's all right.
Deborah Balcom.
I'm back.
Andrea Farentholt is absent. Chandler Crouch.
Present.
And presiding officer Steve Mills.
Present.
Okay, we have a quorum.
Thank you, Carmen. So we are going to move item G ahead of the staff reports. So going to call on John Medlock, the Chief Prosecutor, for his presentation and discussion of the Enforcement Division and processes of complaint cases.
Good morning, everyone. Again, yeah, my name is John Medlock. I'm the Chief Prosecutor here for the Enforcement Division. I'm going to share my screen and we can go over a PowerPoint that I have. Let me know if you guys can see that or not.
Yep.
Perfect. Okay, so this is kind of an overview of the Enforcement Division process. It's been definitely a while since we've had a meeting, so some of you that are new, this will be brand new information. And so for the ones that have been on the board, this will hopefully be a refresher course of how we do some things within the Enforcement Division. To kind of start with TDLR, we are functionally aligned. We have kind of two big kind of services. We have the new lottery and charitable bingo section, which was just transferred to us this past legislative session, but we have kind of TDLR's licensing and regulatory services division, which we call it, under which we have 6 different divisions: customer service, licensing, education, examination, field inspections, compliance, and then obviously enforcement, led by our director, Ron Foster. And again, I am the Chief Prosecutor of that. Looking further into our division, as you can see here, we are quite a large division with a lot of people. We have our intake section, which all the complaints come into, and we'll talk about that in a section. We have our investigations section, which does all the investigations. And then we have a prosecution section, but it's split into 2 kind of sections. We have the prosecutors, which I oversee, and then we also have the prosecution legal assistants who assist the prosecutors with the cases and drafting of the documents that we'll talk about here in a little bit. Just kind of a big overview. Again, we've got 41 programs here at TDLR. It's quite a lot of programs that we do regulate. The way that we do it in the Enforcement Division, much like how the agency silos different functions, is we also do a kind of a siloing thing, is we break these programs down into like programs. So we have a building and mechanical section, what we call a beauty and wellness section, transportation, health-related inspections, because some of our programs do have an inspection component built into it, criminal history, and a consumer and financial services. Property tax consulting fits into that arena. So basically what we do is we've got these different teams. I have set prosecutors for each one of these teams, and those folks handle the cases that come under those. In terms of licensees, we have nearly 800,000 individual licensees plus company licensees. I think that puts us at well over 1 million with over 200 different license types. And we do perform nearly 300,000 inspections every year. Just in terms of prosecution, if you look at it, just our last fiscal year for us is from September to August. So this would have been September 2024 all the way till the end of August of 2025. We opened up nearly 13,000 cases, closed about the same amount, had 1,600 orders signed. We assessed nearly $5 million in penalties and collected nearly $2 million. The thing that I pride myself most on, or at least my team, because they do a great job in this, is we returned nearly $1 million worth of restitution to complainants. That's money back in Texans' pockets, and that is something that I'm definitely proud of. Also, you can see that there's a link right there. All of our complaint statistics, not just for the agency, but for every single program, is broken down by, I think, the last 4 fiscal years, and they can be found on our website. So there are some different links on our website. You can go take a look, and you can go see specific breakdowns of complaint statistics for each program. That was a result of a sunset bill that asked us to kind of put that information out on the website for the public to use. Okay, so how do we do it? How do we review our cases? There are three main types of cases that we have. We'll really talk about just the complaint-based pertinent to y'all's type of program, but we do have what we call inspection or kind of departmental cases. Again, like I said, some of our programs where we have a division, our field inspections division, go out and actually perform what we call risk-based inspections, and we'll send those reports to a subset of cases called our criminal history cases. Every licensee that comes through TDLR does have to answer some questions about criminal history. The question is, if it's a new application, have you ever been convicted of or placed on deferred adjudication for anything other than a minor traffic offense? And for renewal, it's basically the same question, other than it says, since your last renewal, have you ever been convicted of or placed on deferred adjudication for anything other than a minor traffic offense? Depending on what is based, what those crimes are, we do check through DPS, the Department of Public Safety background check. Some of our programs also have fingerprints, so we get to access FBI records as well. Depending on what the crime is, if it goes against what we call our criminal conviction guidelines, we will open up a case to either deny that application or revoke that license. But what we're really here for is to talk about the complaint-based cases. So let me kind of get you to that. So this is kind of the life cycle of a complaint-based cases. Like I said, typically it starts with a consumer or someone filing a complaint with the department. We do have an online portal for that. We do also receive fax, mail, occasionally a phone call here and there, where we ask the people to list out who the complaint is against, kind of a detailed description of what it is. There's also the ability to attach any documents that they might need on that online portal as well. But that's kind of how it first starts. Intake's job is to review that complaint for jurisdiction. Essentially, we ask ourselves two questions. One, is this a program that we regulate? And two, is it something that is being alleged that we can actually do something about? Now, the first part of that question is again, with 41 programs, we do occasionally get complaints against a plumbing board or maybe some kind of an engineering question or complaint. Those are two programs that we do not regulate here at the department. So we would obviously close those things at intake. If that first question is satisfied, then the next question is what is being alleged something that we can actually take action or potentially take action against? And what I mean by that is, if in the world of air conditioning, if your neighbor has an air conditioning system installed in their house and it costs them $10,000, 2 weeks later you have the same company have the exact same system, everything about the installation in y'all's houses are the exact same, and it costs you $12,000, and you're like, you file that complaint saying, hey, my neighbor paid 10, I paid 12, that's not right. Well, price is not something in that world, in the air conditioning world, that we regulate. So that would be a case that we would close right there at intake, because it does not allege any violation for which we can take action. Now, if they're alleging that something went wrong in the installation, the system doesn't work properly, then yes, that is something that we can take action for. So we would move that case over to the next section and assign it to an investigator. Now, when the investigator gets that complaint, their job is to contact, obviously, the complainant and the respondent to try to determine the facts necessary or what happened in that. They ask the who, what, when, where, how, why questions. Occasionally, there will be some of our cases that do need an expert report. Usually that's in our health-related programs when there are allegations of standard of care violations that might have happened, especially like in our podiatry, some of our hearing fitter and speech pathologist type cases that we do handle. So their job is to try to investigate what happened, find all the facts, collect any evidence. Sometimes it's documentation, sometimes it's testimonial, occasionally photographs, or even sometimes physical evidence. But their job is to collect all that. If need be, collect an expert report from an expert that we either have on staff or that we contract out with. And then at that point in time, write a report. They're not going to say what they think happened in terms of like, we think this is a violation. They're just going to write what the facts are and what they uncovered and who said what and what documents that they received. Ultimately, that report will go over to a prosecutor and a legal assistant for their review to determine what the outcome of that case can be. So in looking at that, essentially, what kind of options do we have? We've got about 3 options that we can handle. We can either close the case, we can issue a warning, or we can issue what we call an NOAV, or a notice of alleged violation. So what does that mean? So a closing letter means that we have determined that there's not legal sufficiency to move the case forward to that NOAV, or that notice of alleged violation. It could be that maybe some restitution was made, or some corrections or some modifications to whatever the issue was made. And so we might close that kind of informally. Occasionally, the complainant will, throughout the course of the investigation and the case process, might decide to withdraw the case, and they might send us a message saying, "Hey, I would like to withdraw my case." So those are kind of the ways that we will close a case. And the next kind of thing is a warning letter. So warning letters there's sometimes that there's typically been a violation, usually a kind of a lower level or a more minor violation, and corrections or modifications have been made or have been attempted. It's usually kind of sometimes maybe in the first kind of violation for that particular responded kind of area. So we will send out a warning letter to just let them know, it's like, hey, we see what you have been doing. It's a violation, but you've cleaned up your act. You've made some modifications, some corrections, but just know that we're going to keep an eye on it just in case this behavior continues. And then finally, we can issue what we call the notice of alleged violations. That is when we have determined that we're going to seek either an administrative penalty, an administrative sanction, or both against somebody. There is also a possibility of requesting injunction, and we'll talk about that here in just 1 second. So on the notice of alleged violations, so we issue these when we think that we have the sufficient evidence to support the allegation that the respondent has either violated that program rule or statute, or a combination of the two. Again, the results of this could be anything from an administrative penalty to administrative sanction, or both. So administrative penalty, think in terms of money. We can issue fines against somebody. An administrative sanction means that we're going after your license, and it can be all the way up to, depending on the severity of the violation, anything from revocation being the most severe to some sort of probated sanction, like either probated suspension or probated revocation, where you basically have the sanction, but it's been kind of told, and you can still practice your particular profession, just so long as you don't get any more violations during that period of time that license has been probated with that sanction. Now, each program has their own unique EP, or what we call an enforcement plan. Again, those can also be found on our website. So what is the enforcement plan? The enforcement plan kind of takes all the laws and the rules for a particular program and puts it into a document that kind of is grouped by classifications in terms of Class A being the least severe type violations, usually to Class D being the most severe type violations. And then we will also group kind of like violations. So you might see some administrative violations, maybe some standard of care violations as a group. But each one of those classifications will have a different kind of penalty range within it. We find typically that the ranges have worked best for us when we go to the State Office of Administrative Hearings, which is where we have all of our hearings, because we used to have first, second, and third violations, which this program still does, and we're still working on that. And we can talk about that in the enforcement work group. But the ranges, the judges were having a hard time saying if something was a first or second. So giving us a range of violations allows us to, depending on the severity of the violation, we can go either up or down within that range. Again, as the classifications go down in level of severity, the penalties and the sanctions also increase. So typically, it could be anything from a warning letter to, maybe a $2,000 violation for a Class A, somewhere from a $2,000 to a $4,000 violation for Class B. Class C is usually somewhere in 3 to 5 Again, starting to add some of those sanctions into those, and then Class D is usually $5,000 and or a revocation of a license. So that's kind of what that enforcement breakdown is. We are bound by the enforcement plan. When I say we, the department is, and my attorneys are bound by that document. So we will not go outside that range. Our commissioners are allowed to go outside that range because Chapter 51 puts in the authority of we can assess penalties of up to $5,000 per day per violation. And that is what the commission authority is. At the same time, this enforcement document is what kind of binds us, because we want to make sure we have consistency across the prosecutors that are working this program, so that you don't get either the tough prosecutor or you get the more lenient prosecutor. So that way we can have hopefully a consistent basis all the way across. Now, when we issue one of these notice of alleged violations, essentially one of three results can happen. We can either have an agreed order, a default order, or a commission order. And we'll talk about that right now. So all of our notice of alleged violations, as you can see, are discounted at 75% of the full penalty. And that is strictly to encourage settlement. So case in point, if we issue a penalty for $1,000, you will actually see two amounts on that notice of alleged violation. You'll see the $1,000 for the full amount if we have to go to a hearing, or a discounted rate of 75% or $750. And if you decide to settle that case. And to help that, we also include a settlement agreement as the last page for on these notice of alleged violations. So essentially somebody can read it, agree with it, say, yes, I did that, sign the back page, send in their money, and then that will be the end of the case, other than the fact that we will draft up an agreed order and send that out there to them. The prosecutors do have the discretion to reduce the penalty as much as 50% of the full penalty. So in this particular example, they could reduce it to $500. That usually happens when somebody calls us and says, hey, I would like to work with you. Here's maybe some mitigating facts to plead my case. And can we do anything about the penalty? So that is kind of why we sometimes will go up to 50% of whatever the full penalty amount is. But again, that's all because somebody has gotten in contact with us. We've had constant communication. And again, that 75% reduction is to encourage settlements, because as you saw from a previous slide, with nearly 13,000 cases a year that we're going through, any avenue to settle is probably a good avenue. Default orders. So we issue these default orders when the respondent does not respond to our notice of alleged violation. When we send out that notice of alleged violations, we give them 25 days to respond to us. If we do not hear from them within that 25-day time period, we will send out what we call a notice of default, which is essentially another letter saying that here's an additional 15 days. If you do not respond to us within that time frame, this case will go into what we call a default order. Now, when we issue these default orders, we don't issue it for the 75%. We issue it for the full penalty and the full sanction if there was one on that. So there's no discount on default orders because the person just simply has not responded to us. And that 25-day time period is kind of like their due process time frame that is required by the Administrative Procedures Act that Mark talked about earlier. Finally, commission orders. So if we issue one of these notice of alleged violations and the person disagrees with it and wants to take us to a hearing, they can request that hearing, and we will have one before the State Office of Administrative Hearings. That is a completely independent body, is a completely separate state agency from us. It will be held in front of an administrative law judge. Essentially, we will do all aspects of a trial that you would see in like a civil court. Differences is we do all ours by Zoom now, and there is no right to a jury. It's just an administrative law judge, but we still have the same openings, closings, introduction of evidence, cross examinations, all the things that you would typically see in a typical civil case. Another difference is the judge will not issue a decision that day. They have up to 60 days to write what they call a proposal for decision, or a PFD. And essentially that is what they think, based on all the evidence and testimony and witnesses, what they think should happen. to the case, hence a proposal for decision. And essentially, it will be one of three things. They will say, state, we think you carried your burden and that the penalty and sanction is appropriate. And so that's what I'm going to recommend. They can say, state, we think you carried your burden, but maybe the penalty is too high or the sanction is too high, so I'm going to reduce that a little bit. Or they can say, state, we don't think you carried your burden at all. And then, obviously no penalty or sanction will be issued. Those decisions will then go before our commission on licensing and regulation, and that's a 7-member body appointed by the governor, who none of the commissioners can have any interest in any of the programs that we regulate. So they're completely non-biased in this regard. We will basically do what I call like a Reader's Digest version of what happened at that SOA case. So we get about 5 minutes. The other side gets 5 minutes. Commissioners may ask us questions. We have a couple of minutes for rebuttal. Ultimately, the commission will vote that day at a commission meeting on what they think should happen in that case. And typically they either vote to affirm the PFD or reject it. Occasionally they may affirm it and modify it and kind of change some things. So essentially, if we had won the case, they may affirm it, or they may say, hey, we want to reject something that the ALJ did and change it. But ultimately, that will be the final decision and the final order will be issued after that commission meeting. Now, a couple other types of the orders that we do here in the enforcement division are cease and desist. We typically use these in unlicensed cases to halt somebody from doing something. They're very handy and they're very easy to kind of issue out when we get information about unlicensed activity. We also have kind of a unique authority in emergency orders, and it's kind of a special authority that's been granted to our executive director that allows us to shut down unsafe equipment, some unsafe facilities, to revoke licenses. You may have seen a lot news releases from us recently in terms of the massage establishments and our ability to combat human trafficking, where we're using these emergency orders to shut down those places as well. And then injunctive relief. So injunctive relief means that we're actually going into a district court to seek some type of injunction against somebody or something from doing something. The agency cannot go into district court ourselves. We have to get the Attorney General to help us with that. But we typically do that in cases where we've either issued a cease and desist or we've gotten a recent order and we still find that the person is continuing to engage in that particular activity that we've asked them not to do or they've said that they weren't going to do. So we have to go to the Attorney General. They have to sign off on it and agree with us that this is of such an egregious nature that they're willing to go into district court and represent us. Again, typically what we ask is for a temporary injunction for the person to stop. And we get that usually with the hope of getting a permanent injunction for that person to stop. Potential violations of results of violating an injunction that we've gotten through the district court is criminal contempt, which means we're actually, the person would be put in jail, or just additional monetary penalties being added to it. So, but usually when we get these injunctions, we're fairly successful in getting the person to kind of stop what it is that they were doing. And then ultimately, that's kind of it. So if you guys have any questions about the process, I'm happy to try to answer any of those that you may have.
Yeah, thank you, Counselor. We're going to open it to each member. I'll start off with
Mr. Mills.
Yes.
This is Mark Gladney, Assistant General Counsel. But yeah, before we get started, Ed, I do want to caution the board that the questions should be limited only to the enforcement process that's been presented to you, and not to any kind of specific cases that may or may not be before the enforcement division. And John just briefly mentioned the APA, but certainly under the Open Meetings Act, that I went through with you, we do have to make sure we stay within the bounds of the agenda item. And as an additional caveat, there are reviewers in this meeting that could possibly end up reviewing any kind of decision that comes down if a case ends up going to SOA. myself included. So, that's another reason to refrain from any mention of any specific facts in a case, as well as from time to time, commissioners may be watching these meetings. So please keep your questions solely to the enforcement process. Thank you.
Duly noted, and thanks for that reminder. Yeah, so I have a comment and then a question, John. To me, and this is just merely an observation, I'm going to kind of use an analogy. It seems like if you've ever if you've ever traveled abroad, the traffic laws in many of the foreign countries, stop signs and red lights are merely suggestions. And it seems like our rules and our regulations have just been merely suggestions. Nobody's following them. Or there's a new group that's not following them, and there's no action taken. And I think that's pretty much an affirmation today, just from the public comments, the emails that we've gotten, and just the general sense amongst many people that have been in the industry for quite some time and operated at top tier integrity levels. I think there's a lot of frustration. So that's just my own personal comment. I think our rules have just been just treated like suggestions, not really being enforced, and it's very frustrating to watch from the peanut gallery, especially when it affects our entire industry. That's my comment, my opinion. The second real question is, do we have clawbacks? If we see where a violation has occurred for multiple years and there's a complaint made, can you go back several years or see when that first started, or even through discovery find out, well, what was your advertising and what were your contracts? What did they look like? Did you have the notations on your contracts? Did you have the reference to TDLR in your contracts and to your advertising? So I'll shut up and let you answer that, and then we'll go to Deborah after that, and then we'll go to Mr. Dunson, and then we'll go to Artis if you'll go then, and then Chandler if you'll go after him. I don't know that Andrea's come in yet, but if we'll just follow that order for comments and questions for John, I'd appreciate it.
Yeah, just to clarify, so like a complaint is made and alleging something
Whatever.
happened, whatever it might be, and then through the course of the investigation, we discover that maybe this has either been going on for a while,
Right.
something like that. Can we cite them for those additional things that we find? So yeah, to answer that question is yes. In terms of when we're investigating, if we find evidence of alleged violations, we can go back and look and see the history of that. We also will do it in terms of, let's say that we find a respondent in 2020, right? And it's now 2023 and the same violation goes. We can go back in our system and look to see whether or not the person is what we call a recidivist and that they've had multiple violations or what kind of violations they've had over the course of time. And that is used to influence sometimes our enforcement decisions in terms of the penalty, because like I said, because we've got that range, if it's a first time violation, we may go towards the low end of that range. But if we're starting to see precipitous violations that occur, we'll start going up that range and start, if the penalties, if the classification allows it, start adding in some of those sanctions.
And what's the statute of limitations on that? Is it?
So the statute of limitations on a complaint is 2 years. So in Chapter 60 of our administrative rules, which are kind of the administrative rules that govern the agency, it is 2 years from the date of the violation that occurs. So we usually look back 2 years. But when we look back on our previous recidivist history, we usually look back 3 years.
Great.
Mhm.
Great. That's it for me, John. Thanks.
Yeah, absolutely.
Deborah?
Okay, great. Thank you. John, thank you for being here today and for
Absolutely.
that overview. We really appreciate that. I have a couple of questions from the
Mhm.
standpoint of our role as advisory members, right?
Okay.
As Steve has said that we are industry participants, right? We are
Yes.
licensed consultants, and serving on this board, we all take that licensing and that ethical standard very, very seriously. And try to hold up our accountability of our firms and our personal behavior. So my questions come down to, how can we ensure that these complaints and these referrals to the enforcement division are being properly and timely adjudicated? I think that what we're hearing back from industry feedback is that complaints either A, are falling on deaf ears, or B, are just simply not being adjudicated timely. And then where's that accountability? How do we hold the enforcement division accountable as an advisory council, or what's our role with you as an advisory member on saying, hey, let's hold our industry accountable. We have these ethical rules in place for a reason. How do we be more engaged in that conversation and making sure that our members are being heard, making sure our members are protected, as well as the public? I mean, ultimately it's the public that needs to be protected, but as well as our members within that industry. We work very hard at trying to maintain those standards in this industry, and we get a bad rap a lot of times. We want to make sure that we're engaged with you as advisory members. So how do we do that?
Absolutely. I'll take the second one first. So probably the best way to do that is through the enforcement work group. Things that we ask of that work group are two major documents that we always ask for people to create through that enforcement work group is the criminal conviction guidelines. That's again, the set of documents and the set of crimes that we kind of look at to make sure that we're keeping the people in here, or the people out of here that don't need to be in this profession, at the same time to making sure that just because someone does have a criminal conviction in their background, that they're not being unfairly siphoned out. So that's one way that you can do that. Second is the actual, again, like that enforcement plan, that penalty matrix that we talked about. I did mention that it is a little bit older compared to some of our other ones, because we haven't had my knowledge, a meetings, like I said, in I think almost 7 years. But we would ask a subset of that of this advisory board group to serve on that, work with us, help us define what are important in terms of violations. Again, that enforcement, typically the way we do it is we being the enforcement division, will draft kind of a first draft saying, hey, this is where we think these classification of violations should fall. You guys tell us what you think, because you guys are the expert in the field. So do we have something too low? Do we have something too high? Do we have something that's not, are the ranges not broad enough? Those kinds of things. So getting y'all's input in that and getting that document right is the best way that we can kind of hold people accountable that you guys want us to hold accountable. So getting that input. So I would definitely say that I know it's a future agenda item. When y'all get that, let's get that group together to meet. And at the same time too, you guys can bring to us in that enforcement work group what is going on, right? Obviously we have not met in 7 years, so we probably don't know exactly what exactly is going on in the industry that you guys as professionals and deal with this every day probably know. So that's probably the best way to kind of hold us that. In terms of the timeframes, yes, that is something that we are working on. We have, unfortunately, sometimes over the course of this 7 years been plagued with some staff turnover and some shortages. And that has led to some of these longer timeframes in getting cases reviewed. I am slated for 19 attorneys to work underneath me. If you look at it, I have one current opening, I have one about to be open. But there was a point in time that I was down 6 attorneys. And so we were just trying to manage as best we could and get through. Not an excuse, it's just an unfortunate reality of the situation. So, but we are almost at 100%, which is great news for us. But at the same time too, I would also ask, I talked about a little bit about the expert process. And we do have folks in our compliance section. That's where we usually house all of our experts. And sometimes we rely on those. But we don't have a specific person that has this license type in that section. So it may be a situation in discussing with the enforcement work group that maybe we can engage with one or a few of you on the advisory board to serve in an expert capacity on some of the specifics of this. And we can walk through that in that work group to kind of give you what that process would look like and what that would be like. So if we do have questions that are borderline about whether or not something is or is not a violation, we could engage with y'all or someone to say, hey, is this a particular violation? And would it be something that you'd be willing to stand up in court and testify that, yes, I reviewed this, this is a violation?
Mr. Chairman, Chairman
Thank
Mills,
you.
if I can jump in real quick, this is Steve Bruno. I'm Deputy Executive Director for Licensing and Regulatory Services. And just to answer your question as well, that's one of the reasons I'm here at the meeting today it's been so long since this group has met. I am familiar with some of these concerns that you all have, and we share them as well. So thank you all for being here, and thank you, John, for the presentation you're giving. I know you're going to get a lot of questions, some more, and if it doesn't come up specifically, I was going to ask if you could not mention any specific cases, but share any tips on what a complaint that's actionable in this industry, or any advice you have, or any pitfalls you can share from other cases or any other programs that you've seen, so that we can help inform the industry of the best way that we can partner with them to take some action on these.
Sure.
I think in the work group that will occur. I've sent Carmen my recommendations for the different work groups.
Great.
And I think the work groups are going to be very productive, and we'll share those. I don't want to take time today to do that, but
Yes, sir.
give each board member their comments and their questions, their time for that, and then we'll do that, address that in the work groups. I've
Thanks,
submitted
Mr. Chairman.
and
let me just
work groups.
Let me just say also thank you to you. I know you came in person to Fort Worth to the strategic plan session and alerted these as well to me directly for your industry. So thank you for that.
You're quite welcome. It's my pleasure, and find it a privilege to be able to have this capacity. Stephen, I think you're next for comments and questions.
Okay, and Mr. Bruno, I would recommend modeling TDLR after TREC and what Texas Real Estate Commission does. They're very swift, they're very quick. Their rules are in place. And actually, if you look back at TDLR and our history, once we moved over from the board, BTPE, Board of Tax Professional Examiners, over to TDLR, the director of TDLR at that time was Bill Kuntz, who came from TREC. And he put in a lot of the policies and procedures at that time with TDLR to get the complaints going quicker and so forth, to be more swift and determining and what actions were not.
We'll do that. Thank you. Thank you for that.
Sure. So, Mr. Medlock, I'm trying to understand kind of the structure of how TDLR and Enforcement Division is. Do we have prosecutors assigned specifically to our industry, or do we have investigators specifically assigned, or once a complaint comes in, it just gets assigned to whoever's next up, or how does that work?
No. So each level, intake, investigations, and the prosecutors work with a group of cases. So intake, there's a group. It's a few different programs, but PTC is one of them as well. So they're familiar with all those types. Same thing with the investigators. They'll investigate maybe 4 or 5 different types of programs, but PTC being in it. Same thing with the prosecution sections. We have that consumer and financial services section. There's about 9 programs that they regulate, so that's all that they focus on. So PTC is not exclusively within one line item across the board, but it's housed within a group of people. So it's kind of the same people throughout the process.
Okay, and I was encouraged by your comment, without being prodded for it, about expertise in our field. I feel like a lot of times, I can't imagine how many industries you guys regulate, and trying to have expertise in that is just overwhelming. I understand that. But a lot of times when I'm talking to somebody from TDLR, they're unaware of basic fundamental things within our industry that are accepted in rules and in the tax code and even in on some of the forms saying what is and isn't. So I'm glad to hear that you said that. What would you do in a case where I'm seeing a proliferation of unlicensed companies or websites really right now advertising for property tax consulting services? If a consumer or one of us wanted to file a complaint against them, but we don't have an individual to file that against, how is that handled? Do you guys do a search through the Secretary of State's office, or how do you find those individuals?
Are you talking about the respondent person that might be like responsible for that website?
Yes.
Yeah, so once a complaint comes in, we do some basic research to try to find, especially if it's like a company based. So yeah, we do access Secretary of State. There are some other databases that we have access to. If we have phone numbers and things like that, that may give us who the specific individual is that is related to that company.
Okay. And then is the TDLR website right now updated on our licenses? And the reason I'm asking is I was looking at an individual yesterday on the website, and his license had expired 3 weeks ago, let's say, or I don't know how long ago, a month ago. Is it active, the TDLR website on the licenses right now? Do you know that?
I do not know that for 100%, but I would assume that it probably is the most up-to-date information. And Bruno, I don't know if you have anything to share.
Sure, I'll jump in on that, Mr. Dunson. So yes, it's accurate and updated daily. The reason you will see an expired license on there is that it is currently not active if it shows expired, and no one should be working. But our rules allow a late renewal period, depending on the license length. All of our licenses last either 1 year or 2 years, and you actually have up to 3 beyond your expiration to pay extra and renew. And so for that reason, you'll still see a license as expired up until that time that they can late renew. Once that time has passed, it won't show up on that list anymore. But again, part of the reason that we list that information is we encourage the public before they hire anyone to do that search.
Right. And there's some appraisal districts, very few, that will check the license database when an individual's at their appraisal district trying to work. And I'm just curious as how that's being updated.
And to be clear, no one should be working if their license shows an expired status.
Okay. And lastly, Mr. Medlock, I'm wondering if there's ways we can improve this, because I'm looking at the property tax consultants' complaint statistics annually, and the number of days varies tremendously. But last year, for instance, it was 722 days, the average time it took to do a complaint. How do we improve that? And I got and the follow-up question to that is, what type of system does TDLR have to track these? Is it a internal system made up by TDLR? Because I don't understand how we track those. Is it like could you kind of expand on that as far as how that data is arrived at?
Yeah, absolutely. So the way we improve that is honestly, like I said, we've had staffing issues, not an excuse, but a reality. Luckily, we've had 2 folks dedicated to this program for the last good bit of time. So it's why, if you look, I think you'll see in the statistics that number has gone down dramatically over the last between the last 2 fiscal years. But the system in which we do this is it's a third-party vendor system called Legal Files. It's our case management system, and through it and the way it's set up, it allows us to be able to pull all kinds of data and statistics related to like time opening, the number of cases closed in a certain period of time, opened, basically you name it, we can almost pull. I'm not going to promise that we can pull every kind of statistic out there, but there is a lot of stuff that we can do in terms of statistics and data from that system.
Okay, great. I was curious about that because I did submit an open records request to the agents, to TDLR, for all the property tax consultant complaints filed since 2020. And there was a number of cases still open from 2022, 23, 24, and it's getting that's getting pretty long as far as
Mhm.
it happens. And like even a case, let's say that takes 500 days to get you heard one of the public testify today. They file one in 25. My own
Mhm.
personal experience has been a year and a half to 2 years before I get a final type response from TDLR, which I understand that can vary. But I'm hoping there's some way we can really speed that up, because I don't know if that's just because there's confusion on far as what we determine to be violations of our licensing act. I
Mhm.
see a lot of the same complaints going over and over. But if it takes even 90 days, let's say it takes 120 days, by the time that determination's issued, that person you're filing a complaint against has already made their money and gone.
Mhm.
So it's probably asking 60 days is unrealistic, but the shorter the time frame, the better, the more protection you're going to have against consumers, particularly taxpayers. I think you're going to have a lot of complaints this year based on the websites and the stuff I'm seeing on social media.
Mhm.
I've found at least a dozen companies that are operating equity analysis advertising on the Facebook, social media, Twitter, Instagram, all that. Um, in addition to the two newspapers doing it as well that were talked about earlier. So I think it's a big problem right now. Anything we can do that you suggest that we can do to help you guys get this under control, please suggest it, because it's something I get asked about all the time. I got 3 phone calls yesterday from different consultants knowing this meeting was taking place today, wanting me to ask, when are we going to do something about these unlicensed individuals just proliferating the market right now?
Yeah, absolutely. I think some of those discussions that might occur in the enforcement work group might
Yeah.
help with that.
Okay, that sounds great. Well, that's all the questions I have. Thank you very much, Mr. Mellock. I appreciate it.
Nope, thank you, sir.
The floor is yours, my friend. You're muted. You're muted.
Am I up?
Oh, there you go.
Okay. Do want to thank you for your time today, and I would like to echo the comments of essentially everyone that's spoken before me. I did have a question about the statute of limitations. So you said it was a 2-year statute of limitation on the violation. And if I saw that right earlier, it's taken more than 2 years to actually process these investigations. So are a lot of these just like running up against the statute?
No. So that's for the complaint to be filed. So let's say a violation occurred today in 2026. If the complainant does not file that before this date in 2028, most likely we would not be able to open that complaint. So it's not the statute of limitations in terms of from when the violation happened to when the order or whatever the result is. It's from when the complaint is filed. So it's a front end kind of a thing, not a back end.
Yeah. And then the 3 years would look back would be would be 3 years from the date of the violation.
It's usually so like if we had an order or if we had a case that came in today to the prosecutor and we're looking to draft that notice of alleged violation today, we'll look back 3 years from that date that we're drafting it to see if there's any prior orders, prior violations against that person.
Okay. Okay. Again, I would like to echo the comments of the people who've spoken before me, and I don't have any other questions.
Thank you, artist. Chandler, you want to land the plane with Mr. Medlock?
Yes. Thank you for your time. Appreciate it. It seems like the concerns fall into 3 different buckets. There's kind of the bad behavior that's running rampant in the industry and kind of defining a few specific examples of those. And then we've got the length of time from when a complaint is, for lack of a better term, open all the way till close. And then the third one, which is the one that I want to really focus on, I've got a question about, is the enforcement. And I think specifically for me, it's the penalty that I'm most concerned with. So that's just an observation. But my question is, back on these reports, I see, and forgive me if you've mentioned this a little bit already and I just missed it, but it says the under penalties and consumer remedies, it looks like for 2025 and 2026, the amount of penalties assessed, collected, restitution on down the board here, it's zero for the property tax consultant division, but it looks like TDLR overall is doing these things in, I guess, certain industries. And I was just curious why you think that the actual penalties are zero for our industry.
So that would mean in those cases over the last 2 fiscal years, which you're looking at, there were no administrative orders against anyone, which means that there was didn't necessarily mean there wasn't a notice of alleged violation issue. It may have been that there was a notice of violation issue, but maybe something corrected. And so the prosecutor dropped it down to a warning. It may be that there were just more warnings issued. But long story short, it's because nothing went to an administrative order is why there was no penalties assessed.
Gotcha. Okay. Well, it seems to me just that's kind of the end result for me as well. We can talk about rules, we can talk about enforcement, but if there's not a penalty, then it's like, well, then it seemed like more like suggestions, I guess. But let's go up to the very first part, which is the bad behavior running rampant umbrella that I painted there. It seems like it, help me understand. It seems like a necessary part of the process is for somebody to report a violation. So some member of the public or a licensed person to report a violation. And it seems like the system kind of depends on that component, unless there's something else I'm missing. Is there any other kind of arm of TDLR that might go out and look for problems without just letting them see? I'm just trying to understand the process.
No, you hit the nail on the head. This, like I said, this is a more of a consumer complaint program. We do not have an inspection component. So, like I said, some like cosmetology, barbering, massage, they have an inspection component where our field inspections division develop a risk matrix to go out there and periodically look at those different industries. Here, we rely solely on complaints coming in. So we do not have that inspection component coming in. So it could be that somebody in our compliance division notices something, sees something, and they could file a departmental complaint. But typically, we need someone from the public, whether it be somebody in your field seeing something, whether it be an appraisal district seeing something, whether it be a consumer seeing something, to actually go online and file that complaint.
Okay, gotcha. Okay, and I know that we've touched on this, but I wanted to ask this specific question. It seemed like the processing time for a property tax consultant complaint takes significantly longer than the average in maybe another industry or the industries across the board. So I was just curious what might be causing it to be a lot longer, if you have any insight on that.
Again, a lot of times it depended on the number of attorneys I had within those programs. And Consumer Financial Services was always one of the ones that we were having a tough time filling and keeping staff members. So that's always a function of sometimes why those case processing times happened a little bit longer.
Okay, gotcha. Okay, and so it seems like for everything else that I haven't really mentioned, it would probably happen during a work group to discuss the advertising tax savings, the promising result, and then the unlicensed activity stuff. So what work group would they dive into those things on?
Most likely, definitely probably enforcement, where we can look at, like I said, the enforcement plan to see if things are right, and just kind of some general overall enforcement issues or questions. I don't know, Mark, if there's a rules work group, just to see if there are any additional rules that are needed or necessary. But if there is a rules work group, that would probably be another component as well, because if there's not a rule for it, then there's obviously nothing we can do to enforce it.
Okay.
This is Mark Gladney. John, to answer your question, yeah, we're going to have 3 work groups. One's going to be a rules work group. Of course, the enforcement work group is going to be there. And we also created an ethics work group. We thought that there was a need for that based on what we were kind of hearing from some of the members of the board. But if I can just chime in here real quick, I think that Board Member Crouch really brought up a very good point, and that to the board members, yes, this is a complaint-driven type of program, and I'd like to urge the board members, if you see something, say something to us, and members of the public and other PTCs out there. If you see something, let us know about it. File a complaint. The enforcement can't really do the work that they do if we're not totally aware of what is going on. And several board members brought this up, and I think also some of the public commenters. And I'm going to be careful about talking about that, but it's a whole different world that we live in from the time that we were last together. AI and social media has really changed this landscape, and it appears that in looking at the laws that the legislature has passed, we haven't had any really major changes in this industry for as far back as most of them are 2003. There's a few from 2007. I think the latest one that I saw may be 2010. And this was far before social media and AI, came on the scene. And it's pretty clear that there may be some actors out there that are using technology to kind of change things. So, from the legislative standpoint, we may need some more action from the legislature, and also from the rule standpoint, we may need to certainly scrub some of our rules and start taking a close look at them with the 3 work groups that we have, and make some changes that reflect the impact that AI and social media has brought to your industry. And if there's something that we need to correct, we will do it.
Sounds good. I've got, guess a little follow up is I love the idea of improving where we can improve, and then I mean, just having a hierarchy of what would be most important, most impactful to improve. And then the question, I think all these conversations about all this stuff is great, but then my question is, or my thought is, what kind of resources are available to make some significant changes, and what kind of, like what could we expect if we have to get somebody else on board here or on staff? Is there money for another salary, or what kind of budget restrictions are we looking at for coming up with solutions here?
I'll answer that. This is Steve Bruno, Deputy Executive Director. We, of course, we're always going to ask for as many resources as we can, but I don't think it's necessarily a resource issue. Mr. Crouch, right now, I think it's several things. It's the length of time since this board has met. It's a chance. I see it as a chance almost for a reset with these advisory board meetings to take into the things Mark's considered and take into all the comments that you all have brought, because I know that I want you all to know that I appreciate the frustration that you all feel as good actors who see bad things happening in their industry. So I don't think, although we do have staffing challenges, what I want to do is, and the resources that will be provided to the working groups when you get into these are our staff and their experience. And I think working together, especially with focusing on the penalty matrix and on the rules for any changes, and then Mark will let you know as the assistant GC if there's a suggestion that would require a statutory change, then that's something that our government relations team can work on. But I believe that this opportunity today to get back together and get these work groups going again will produce some really good fruit. And during that exploration, if we do find that there are some staffing needs or resources or something that we don't have, then I will work with the enforcement division to do our best to secure those.
Thank you.
Yes, sir.
Well, with that, John, thanks so much for giving us your time and being very candid and patient and going through the process of explaining you're up against. We appreciate that, and certainly that's a concern. But thanks for indulging us. We're encouraged. I know I am. But I think the work groups are going to be very, very meaningful. We're going to leverage them, and we're going to use them to strengthen our industry. Because you see, one common theme that's throughout every one of these board members that have spoken is integrity. We have to have integrity. It takes years and decades to gain integrity. It takes 15 seconds to lose it. So so we'll be back, and you're going to see us, and we're going to have these work groups very active. And with the work groups, I think even with the lack of staff, I think we can probably even leverage AI ourselves and take our rules and compare it to what the violations have been or what we see as very clear violations, and run a matrix on what really pops up. So AI has its benefits, and it has its, just like social media, it has its detriments as well. So I'm sure TDLR has probably leveraged some AI for some of their operations, as most companies are and most institutions are. But thanks again, and appreciate it very much. So with that, unless anyone wants to take a break or anything like that, we can move on, Carmen, to item F, the staff reports. And we'll get first, I guess, briefing from the license division, and Sam Torres with the license permit specialist lead from the license divisions.
Hello, Mr. Chairman, and all our board members. My name is Sam Torres. I'm from the licensing department. I work on the tools team. We're the ones that process the property tax consultant applications and renewals. And so I'm just here to present these numbers to you. You'll see that we do have the fiscal years 2024 and 25, and we're able to get a few quarters in for the fiscal year 2026, and also just a kind of a rundown as far as the number of emails that we receive concerning property tax consultants. It's fairly normal numbers. I don't really see anything out of the ordinary here. If you have any questions about this or the email numbers, I can certainly try to help you with that or answer any questions you might have.
Anyone? Seeing none. Well, thank you, Sam.
You're welcome. My pleasure.
You want to have any questions before we move on?
Sorry, I do have one.
Okay.
Thank you for being here, Sam. So as an industry, just for those who are new to our advisory board, we're still fairly small in the grand scheme of some of the licensing divisions that you regulate, correct?
Yeah, you could say that. Yes, ma'am.
Okay.
As far as my team, we do 16 different programs, and this is probably about average of all the 16 programs that we
Okay.
handle on our team.
Thank you.
You're welcome. Yes,
Okay, we'll move on to item number 2, under staff reports, education examination division. Michael Strawn, Director of Education Examination Division, has a presentation from staff.
Good morning, Chairman and members. As introduced, I'm Michael Strawn. I am the new director for the Education Examination Division as of December 2025. So I may have seen some of y'all years ago in the past working in education as a manager before I left and came back. Anyways, happy to be here today representing my division and to give you our staff report. What you see on your screen, if you'll scroll down just a little bit so they can get a better picture of it. is the pass rates from FY26 to FY25. As you'll notice, and as the member brought up just a second ago, this is a little bit of one of our smaller industries. So with that being said, there are always statistical anomalies to take into account, but we do have a fair share here of, about 69 to 80 different testing candidates per quarter. So it gives us a good outlook of everything. And what we're really seeing is the pass rates remain pretty consistent. We're up ever so slightly from FY25 going to FY26. And that's a lot in part to do with our exam review committees, which I'll touch on here later in the report as well, making sure that the health, maintenance, and knowledge and requirements are all there within our examinations every step of the way. If you'll scroll down for me a little bit further, we'll see the breakout of all of our examinations by the license type. So for the consultant senior, the property tax consultant attorney, et cetera, this is the breakout of every quarter for each of those license types as they exist. Again, it's reflective of the information you saw above it, and we remain pretty consistent from the last couple of fiscal years. If we could scroll down to the last part of this presentation. We have the continuing education courses. We have risen ever so slightly in the total number of course approvals that we have issued. You'll see right now we're currently up to 41, whereas in Q2 of 25, we are at 36. So a slight growth there, but remains within what we expect. And we'll scroll down a little bit further. And then here's our program updates. I mentioned earlier in the first part of this, with every one of our examinations, no matter the size of the industry, large, small, we perform exam review committee meetings in tandem with our licensees that are selected to serve on this committee, along with our psychometrician and our vendor, along with subject matter experts that we house here at TDLR, to make sure that there's any changes to law and rule. Those are updated within the exam. If there are any underperforming or overperforming items within an exam, they're addressed as well. So the entire exam review committee, consisting of all those individuals, reviews all of these items to make sure that we're still asking good questions, that they're appropriate to be asked of that license type, that we're making sure that we're looking for a minimally competent candidate for licensure. So that's something we continue to engage in no matter how often we have advisory board meetings. Within the last one that we performed, they reviewed 30 existing items, 3 of which were deleted, 21 were edited due to either overperforming or underperforming. And then they wrote and approved 13 new items. So they were busy with their exam review committee. And lastly, some staff updates. It's been a while since we've hired additional people here. But we were happy recently to onboard Michael Wilson as an audit and assessment specialist and Trin Lamb as our exam and course review support. They're really big additions to our team, helping with our auditing and with our exams to make sure that we can provide better services across the board, whether it's making sure that our continuing education courses that are out there are providing relevant and competent information, and that our exams are delivered timely, resolving any issues that may exist. So we're really happy to have them on board. It's really bolstered our staff and our ability to do our job more efficiently. With that being said, that concludes my report, and I'm open to any questions you may have.
Anyone?
I have one question. Steve, do you mind if I ask a question?
Not at all.
Okay. Does TDLR track the education that the people that are taking these exams, where they obtain it from? Like, is it an online course or in-person course? Do we track that at all?
I don't have that level of detail as far as the manner in which they have taken their course. For some of our courses, we do have the providers registered with us. Whether that methodology in which it was delivered, I don't believe that we have that. I could certainly look into it and provide if there's any. I assume you wanted to see if there's any difference between the knowledge gained between somebody who went to an online versus in person.
Yes, I'm kind of curious about that. It's not a pressing issue. If you can do it over time, that's great. But I'd like to just kind of see. I don't know if these online courses are as effective as in-person courses, and I'm just curious. But it's not a pressing issue at all.
yes, sir. I'll see what we can do. I can't promise anything, but if we receive that information as far as how it's delineated, we will be able to gather that for you.
Sure, no problem. Thank you.
Stephen, thanks for serving on the Education Testing Committee. Uh, uh, It's a thankless job. Really appreciate it.
Thank you.
Carmen, I'd like to take a 5-minute break.
Oh,
and
I have
come
a
back. It
quick
is-
question.
Yes.
Okay, on your continuing education approval page on
Mhm.
there, and again, Michael, thank you for being with us today. Is that broken down, is that just continuing ed, or does that also include the new license education 40-hour course? So we have two different sets of courses. We have the new licensing that's contributory to that exam, right? And then you have continuing education that's contributory to our 12 hours, 24 hours per renewal. Is this everybody, or do you have that breakout?
This should just be the continuing education providers. I will confirm with my management analyst that that's what was rolled into this, but it should just be the CE
Okay.
courses only.
And would you then give us next time on it, could you give us how many are the new licensee classes? How many approvals we have for that? To Steve's question on testing, my understanding was that class had to be in person. I didn't think that class could be online, but I don't know if that's correct since COVID. I don't know if that rule changed or was laxed. It used to be that had to be an in-person class. I'd be curious as to that, as to who's providing those new license classes that are out there, contributing to that pass-fail rate. Okay, that's all. Thank
Yep.
you.
Yes, ma'am.
Anyone else have any questions? If not, let's take a 5-minute break. It's 12:05. Let's return at 12:10. Thank you. And thanks everyone for indulging me.
Stephen Dunson,
Present.
Deborah Balcom,
I'm present.
Artis Connor,
Present.
Chandler Crouch,
Present.
and presiding officer Steve Mills.
Present.
We have a quorum.
So with that, we'll proceed with the staff reports. In item number 3 is Customer Service Division and a report from Myra Rodriguez, Customer Service Manager with statistics.
Good morning, board members and TDLR staff. I'll be reviewing our customer service contacts for the fiscal year 2026. Overall, we're seeing steady growth in customer contacts throughout the year, increasing from the 83 noted in September at the beginning of the fiscal year to the peak of 273 contacts for the month of March. This reflects a strong upward trend specifically in the later months of the year. In terms of contact types in customer service, the vast majority of contacts are phone calls. And this concludes my report. I'm happy to answer any questions that you might have.
Got one question. What are most of those calls pertaining to?
We don't have the data for that. It could be anything from continuing education or license status, renewal information, or request for information responses. So it could be a vast majority of either of those topics.
Okay. Anyone else have any questions?
I do. Are we working on, and I don't know if this is your department, but thank you again for being here today. Are we working on the ability to renew and to communicate more online and renew online, pay or apply online?
This is Steve Bruno, Deputy Executive Director. Yes, we are. And I will have an update about the new system that we're working on during the report I give later on.
Sweet,
So,
thank
excellent
you.
question. Yep, thank you.
Yeah, but that was one of my questions as well, and something I stared with Steve when we had our in Fort Worth a week or so ago as well. We should at least be able to pay online for sure. So I don't have checks, or as my grandkids say, do checks. Next, we'll move to item number 4, which is the Enforcement Division, and call on Rebecca Burkhalter, the Senior Prosecutor for the PTC. Thank you, Rebecca.
Good afternoon, Property Tax Consultants Advisory Board. My name is Rebecca Burkhalter. I'm a senior prosecutor with the Texas Department of Licensing and Regulation. I have the Enforcement Division's staff report for you today. The report combines 2 similar timeframes and data from the beginning of the fiscal year through February of each fiscal year. We're trying to make sure we're combining 2 similar sets of data. We will start with the performance measures at the top. This program doesn't have a high number of complaints filed, but we're working on bringing down that middle number, the average time for closing complaints, by trying to finalize cases more quickly, as Chief Prosecutor discussed earlier. The middle section here shows the criminal history reviews that are conducted for folks wanting to become registered. There's very little action on this section of the report. The bottom of the first page shows where our complaints were received from, either from departmental staff or from consumers and the general public. Compares that number to the caseloads within the PTC program. So for example, at the beginning of fiscal year 2026, enforcement had 7,651 open cases. 27 of those are on the Property Tax Consultants program. These last 2 fiscal years do not show any official department enforcement action. And then because there was no enforcement action, there were no orders issued, nor any penalties assessed or collected. We also did not revoke or suspend any licenses. You will see at the top of the next page, we did have several cases closed for insufficient evidence of a violation, and we did close 6 cases with a warning letter. The last 2 sections detail what violation was used to establish the department had jurisdiction to turn a complaint into an official case. Many of them are alleged ethics violations in the past time frame, but no official disciplinary actions for either fiscal year. And I'm available if you have any questions regarding these statistics.
Rebecca, it would be interesting to see, since there has been a proliferation of a lot of these new online companies, what the history is for fiscal year 22 to present. So maybe in the work group, we can look at that information, because I think it might be some pretty compelling number of cases that might have gone up since there has been so many new companies that have come on, and with that, a lot of new violations or appearance of violations. So we'll probably be asking that in the work group.
Yes, sir. And just to let you guys know, enforcement does have our complaint statistics online for each of the fiscal years. That information is already available at your fingertips. It goes back all the way through fiscal year 2020.
Okay, perfect.
So
That's great.
the information you're asking for the work group is actually available to everyone online.
Okay.
Any other questions?
And right now you have 27 cases that are open at present. Is that correct?
That's what the report says, sir.
Okay. Well, thanks so much, Counselor, and I'm sure we'll be talking sometime later this year.
Yeah, I look forward to the work groups.
Thank you so much. Number 5 in our staff reports is the Compliance Division, and we'll hear from Morgan Dreyer, Consumer Protection Multi-Program Specialist.
Good afternoon, Chair and board members. My name is Morgan Dreyer, the Consumer Protections Multi-Program Specialist with the Compliance Division. Thank you for the opportunity to provide the staff report for the Property Tax Consultants Advisory Board. The Compliance Division welcomes me, Morgan Dreyer, as the liaison for Property Tax Consultant Matters, effective as of July 2025. In this role, I'll serve as the primary point of contact for the program's coordination, stakeholder engagement, and policy interpretation across the PTC program. In January of 2026, I participated in the PSI examination review for the PTC program. The purpose of the review was to assess exam content for clarity, relevance, and alignment with the program standards and regulatory expectations. Our division receives frequent questions forwarded from the customer service desk. Most inquiries concern registration requirements for property tax consultants and senior property tax consultants, and educational and continued education requirements under the applicable rules and statutes. We continue to focus on timely, consistent guidance. Where appropriate, we refer stakeholders to the relevant rules, forms, and resources to streamline access to official information. The Compliance Division is open to any speaking opportunities or any questions and concerns in related to the PTC program. You can contact me at morgan.dreyer@tdlr.texas.gov for any questions or concerns. I appreciate your time and welcome any questions or suggestions from the board. Thank you.
Morgan, how often are the tests reviewed for content?
I believe they're reviewed every 2 years. I can let board tell me if that's different, but I believe it's every 2 years.
Good afternoon now. Michael Strawn, Education Examination Division. So yes, at a minimum, we'll look at every 2 years. We try annually for most of our programs to make sure we have an exam review committee held for them. And then obviously as needed, if there were any code updates, any law changes, we will always schedule an exam review committee at that point in time to make sure that we're incorporating those updated changes into the questions.
So it probably follows at the end of the last legislative session. So there'll probably be another one in 29 or actually 28, I guess.
At a minimum, sir. One of the things I'm really challenging my exam vendor to do is make sure that we're looking at all these exams at least annually. And that's been something that we've been somewhat successful on across most of these.
Great. Well, Morgan and Michael, thank y'all both very much for your time and the information.
Yes, sir.
Thank you.
And last but not least, Mr. Bruno, Deputy Executive Director, who we all know. Mr. Bruno?
Thanks, Mr. Chairman and advisory board members. Really appreciate the discussion and the meeting today, and it's really great for me to be here with you. I want to give you several updates since, as you all know, it's been such a while since you've met. One of the updates is that the last time I was involved with this group, I was in government relations, and about 2 years ago, I moved into the Deputy Executive Director role. In fact, since the last time you all have met, we've probably had several changes in the executive office. There was about a 14-month period when we had almost 100% turnover. Our executive director is Courtney Arbor, who's been on the job a little over 2 years now. She came to us from the Workforce Commission and has been stepped in and just really done an amazing job taking over this agency. Also, while continuing to absorb new programs. Last session, we were given, as you all know, responsibilities for the lottery and charitable bingo. We've got a new project going on that we're excited to talk about, and that's the modernization of our licensing system. I was actually government relations officer several years ago when we attempted this and were not successful. We put out a bid and have been engaged for just about a year with a company called CGI. And we are working program by program to bring modern, secure systems that include online payment, absolutely, to all of our programs. It's going to be about a 3-year project. At the beginning of next month, we'll roll out the first 3 programs, and your program is still being scheduled approximately for we're looking at a target of approximately September or October of this year. That's an approximate timeline right now. I know that you all can appreciate that if you've worked on big projects like this. Let me give you a little bit of history. What's happened over the years as TDLR, someone mentioned earlier that, you all used to be regulated by the Board of Professional Tax Examiners. And then that was transferred and that agency was essentially dissolved and those duties were given to TDLR. As that's happened over the years, the first questions we would always ask is, well, what kind of system are they using? And we would make plans to incorporate that into our system. But as things compounded and piled on, that didn't happen. And at one point, we were operating using about 14 different systems to operate these programs. And so now we're down to just a few. And ultimately, as I said, the goal at the end of this project will be to have one system. And, there are things that we have to take in consideration now that we didn't before. We mentioned AI earlier. When this program first came to TDLR, cybersecurity and cyber attacks were not things that were on our radar as concerns, and obviously they are now. All the data that we have, it must be protected. And we also must provide better customer services to you, our external customers first, and then to us internally as well. What I mean by that is thinking about the staff in the licensing division who are processing different types of licensing, going back and forth between 2 different systems that are not the most modern. It's not efficient, and it's not the way that we want to operate our business. So we're excited about those changes coming up. Again, I want to reiterate my thanks to all the staff who've presented today, and especially to those members of the enforcement division. We hear you and your concerns, and I want to reiterate my commitment and our agency's commitment to working on these issues with you all so that we can make sure that our enforcement activities are meaningful and that they return as much integrity. One thing that you said, Mr. Chairman, struck me so much. The years that it takes to build up integrity, and I believe that was your comment, sir. I'm sorry if it was someone else, and then that's eroded in seconds, and that's something that we have a role to play in, and we take it seriously, and we take. I'm excited for these work groups to get going, and I'll be involved with them and receiving updates from staff. As we get closer to the launch date of you coming into our new system, it's called TDLR Core, CORE. We will be reaching out to you, Mr. Chairman. We're implementing a system where we'll be reaching out to advisory board members at the beginning to have you play around in this system, take a look at it, see what you think, give us feedback. So that's one thing you can look forward to in the future. Other than that, that's what I really wanted to update you on. Oh, excuse me. We are going through, as you know, Mr. Chairman, our strategic planning process. And so please look out for that report that will be coming and provide us any suggestions that you'd like. And I know that one of the suggestions from this industry is focused enforcement and a stronger look at that, which I am excited again for those work groups to get going and look at. But I'm happy to answer any questions.
Thank you, Steve. Yeah, I did attend the strategic planning meeting that was in South Fort Worth. Y'all had multiple going on that day, but one of the takeaways that I was really kind of surprised by, there wasn't a lot of people there, but what I did find was it was one tax consultant, some people from driving schools, and people from salons.
Mm-hmm.
And my suggestion, quite animated, would be to have a strategic planning session with just our industry,
Yes.
with members and advisory members without having a quorum there, because to me, it was just hearing other industries' war stories, and it really wasn't productive.
Yes, sir.
So that was my takeaway. But I know there's limited
appreciate
resources,
that.
limited people, and limited time. But I think you would probably, if there's plenty of notice, that you'd probably find a lot of people show up.
Yes, sir. And I also know that you made the suggestion that we could perhaps, and of course, you brought up the quorum concern, and we'll work with our attorneys to make sure we don't come into that, but possibly using this advisory board and these meetings as opportunities in the future for strat plan input. And I appreciate your suggestions, and we will be exploring them and putting them into place where we can.
Thank you, Mr. Director. Steve, we really appreciate it. Appreciate your commitment to our industry.
Yes, sir. Thank you.
And so we'll move, Carmen, now to item H, which is the reappointment of advisory board members to program work groups. We have the Rules Development Work Group, which is duties to include general rules governing property tax consultant registrants, including registration, pre-registration, and CEU continuing education requirements. 2 is the Enforcement Group, duties to include criminal conviction guidelines, the penalty matrix, and other enforcement-related matters. The PTC Ethics Group, duties include review and development of rules related to ethical and professional responsibilities of PTC's registrants. Of course, we need to assign board members to those different work groups, the rules development, enforcement, PTC ethics. I had sent Carmen my suggestions that if I live in the land of wish most days, but I sent her what I would who I would like to see on different work groups. They're merely suggestions, wide open to, if you want to tell me to pound sand, if you're not interested in that group, or if there's other specific groups that you would like to serve on. You're not going to hurt my feelings if you tell me just no, Mills, you're off base. But what I sent her, Carmen, you can read it.
If you don't mind, if you could go ahead and review it with me.
Yeah.
So we had you as the presiding officer under number 1 under rules development, and we also have Deborah for number 2.
Yep. So I can tell you what I had for rules, because we can have 3. We can have 3 advisory board members without getting to a quorum problem. I did find that out after I'd sent it to her. But what I have for rules is myself, Deborah, and Artist. And enforcement, I had Deborah, Stephen Dunson, and myself. For ethics, I had Chandler, Andrea, and a public member that is yet to be named. And actually, it would probably be better, Carmen, if you took me off of the rolls and put Stephen on that.
Okay,
So it would be Stephen on enforcement and rules,
got it.
Artist on enforcement and rules, and Deborah on enforcement and rules. And then I can jump on with Chandler on ethics until we get our third public member going. Open for comments, suggestions, denials.
I would love being on
overruling me,
rules. Thank you,
whatever.
Steve, for that. I am happy to have another member jump on enforcement if somebody's feeling very strongly about that. Obviously, I have my strong opinions about it, but if somebody else would like to jump on that committee as well, I'm happy to step aside on that one. I would prefer to be on the education, rules development, and registration redevelopment over
Okay.
enforcement if I were picking one.
I'll jump on that one then, on the rules.
Who was
No,
that?
I want to be on the rules.
Oh, you want to be on, okay.
Yeah.
Okay. You want to come off the enforcement?
Yeah.
If somebody else feels strongly about it. Otherwise, I'm happy to serve at your pleasure.
Okay.
Any volunteers for the enforcement work group?
Who do you have on enforcement right now?
Stephen and you
Okay.
with Deborah, but Deborah's asking.
Okay. Artist or Chandler?
I'd like to do it.
Okay.
Artist? Okay.
Yes.
So that means you'll be both on the rules and enforcement work group.
That's correct.
Are you okay with that? Okay.
Yes.
Carmen, this is Mark Latney. Can you tell me who's on the ethics work group again?
Chandler and Andrea, and then Steve Mills interim until we get the public member on the board. And I can send you all a copy of this document after the meeting.
Okay.
Chandler, what's your thoughts? You're being wickedly quiet over there.
No, I was just happy to go with your recommendation. I trust your judgment. You know probably all of us better than any of us do, and so I think this looks great.
Okay, thank you.
This is Mark Latney, Assistant General Counsel. When do you all think you might want to meet on some of these work groups? I understand this is your busy season. So I'd kind of like to get an idea as to when y'all might want to
Are we
do
meeting
that.
in person or online?
It would probably be a hybrid. Some people like to come in and sit with staff. You know, if you're local, you know, some folks like to do that. Otherwise, we would just do it through probably, you know, Microsoft Teams or something of that nature.
I would
Whatever's going to
suggest
be
nothing
easiest for the
before
work group.
September.
Okay.
Pardon?
I would suggest nothing before September.
Okay. Now, rest assured, again, this is Mark Landy for the record. Staff is, you know, working on, you know, these issues, and certainly we'll be working on the issues that you brought up in today's meeting as well. But, you know, while we may not necessarily have an advisory board meeting, staff is working on PTC issues throughout the year. You know, there's various other things that we're doing, as you can see from, you know, our staff reports. We're meeting with various vendors. We meet with other related agencies. We have a lot of discussions with the comptroller's office related to both PTP and PTC throughout the year. So We may not be seeing each other, but we do have regular meetings to discuss, issues that we're aware about.
So I think board members, any recommendations you have for the next meeting? I'm sure it's going to be in the fall, I would suspect. September, October, November, you start getting into the holidays, be kind of sketch. Before we move on, Carmen, will you remind me who all we show on the enforcement work group?
Artist, Duncan, and you.
Okay.
And I'll be sure to send this document out to you guys.
Is everybody good with the work groups?
Yes.
Everybody feel warm and fuzzy on that? Let's just put out there October for work group.
Well, can I make a suggestion, Steve?
Yeah, sure.
Our state association conference is October 7th through the 9th. So we could have work groups going before that, and sometime in September, that would be great, because we're going to get asked about what's happening by fellow members or at the conference. So maybe in September, if we could have a work groups by then, and then maybe our next meeting be, I don't think we can get in before that. Oh, maybe we could, maybe before 7th through 9th of October, but if not, immediately thereafter, to give people feedback that we're getting ready to have another meeting and let them know about it if they want to participate again.
Yeah, it would open up a good opportunity for a lot of public comments for that meeting. If we do it after the association, because we'll have a time to discuss it with association 7th through 9th, and then have public comments available during our meeting. So say mid-October to late October.
Let's do work groups in September and then meet in October.
Yep.
Yeah, that's what I was thinking. I don't know. What do you guys think, Chandler and Artist?
I think it's great.
So maybe third week in Carmen, third week in October, we could set a meeting,
And
next TDLR meeting.
is TDLR presenting at our conference this year? Sometimes we do. Steve, would you be interested in being on that conference presentation group to give an update on our advisory committee as our chairman?
Be happy to.
I happen to know our president of the organization and the conference chair, so she works for me.
Okay.
I'll ask her.
Be happy to.
It's in Irving this year, Steve, so it's not a
great
long trip.
Yeah.
That way we could reassure our members that we're working on this. I think that would be really important because our members are afraid that TDLR isn't hearing them. And so I think that would be important.
I do have a session going for IPT this year for the symposium, and I can't remember the dates, quite frankly. I can tell you pretty quick when it is that I have to do. Committed to that.
That's into September, it looks like.
IPT.
Is it in Orlando this year, the one you're going to?
It's in Aurora.
Oh, that's in November.
Is it?
November 8th through 11th.
Oh. Okay. Yep, that's perfect. Sounds good. So that works. Agenda items. Do y'all want to just send Carmen some recommendations for agenda items for the next meeting, or do you want to discuss them now? I know we've got about 20 minutes left on the block of time that we have carved out for this. Do y'all just want to send her future agenda items?
Yes.
Yes.
Yeah, I know there will be some coursework group discussion and findings. That will probably take a good portion of it. And I guess that pretty much, the only thing I do want to put on there for sure is getting more participant friendly on payments and registration for renewing licensing.
Yeah, an update on the new core system.
Yeah, that's key. But is there any other items that we need to discuss? If not,
Okay,
we'll
Mr.
we'll
Mouse.
adjourn.
So we've got item I, the recommendations. You guys will email me later.
Yeah.
And then item J, discussion of time and date. We're going to be looking towards our next meeting mid-October. Is what we were thinking.
Yeah.
Okay, I just want to make sure we are all on the same page. And then now we can go to item K.
Yep. So with no further business, this meeting of the Property Tax Consultants Advisory Board is now adjourned. Thank you all so much for your time. Is now 12:41, ahead of schedule. We got 20 minutes to burn. So thank you all, and we are now adjourned.